start.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nabiha Anisa binti Ahmad. For today, me and my friends consist by Samira binti Masaid, Nurul Farhana binti Baharudin, Syahidatul Husna binti Ibrahim, Wan Nur Fatihah binti Wan Azhari. We will present about one article. The article is about issues and proposal toward the implementation of ta'zir punishment for crimes of corruption in the Syariah Court of Malaysia.
We go to the first one. My name is Nurul Farhana binti Baharudin. My metric number 057324. We go to the first one, which is issues related to corruption crimes. As is well known, corruption is a matter of concern and needs to be given serious attention. Each year reported various corruption-related cases through electronic media or mass media. People, especially the government, cannot leave things like this, and this kind of issue needs to be addressed immediately because it involves the country's future. Thus, most of the researchers felt that a study should be done on the effectiveness of the punishment allocated to corruption crimes perpetrators. According to the statistics released by the Malaysian Anti-Corruption Commission, MAC, or also well known as SPRM, there is an increase concerning corruption crimes. Even though there are provisions in the Penal Code, the Malaysian Anti-Corruption Act also deals with the punishment for corruption offences. This matter shows that the punishment that has been provided seems too light and does not cause fear and terror to the society, and which they are not afraid to commit and engage in corruption crimes. Furthermore, too many cases related to corruption offences were reported pending in the civil courts due to the various problems resulting in many cases being dropped. Because of the large number of cases, the civil courts became tense and the issues had to be dropped, and the offenders escaped the punishment. As a result, the researcher intends to research the application of ta'zir punishment in corruption crimes to aid in resolving this issue. The researcher will highlight the concept of ta'zir punishment, the method of conviction, and the appropriateness of ta'zir punishment in the context of Sharia crimes in Malaysia. Next slide. Next, the concept of corruption according to Islam. The word corruption is a word that comes from the Arabic language, which is arashwa, arishwa, or arushwa, which means something given to invalidate truth or justify falsehood. It also means something achieved with him to some purpose by bribery. Therefore, the definition of corruption can be divided into several categories, and these as things as follows. First, arashi, which is the giver of bribes. Second, al-murtashi, the recipient of bribes. Third, al-rash, something made by the giver and receiver of bribe as connection to achieve a goal. Fourth, al-istirshad, asking for bribes. And lastly, al-rashwa, al-warshawi, bias or preference as mentioned in Lisan al-Arab. Next. Other than that, there are also several definitions of corruption which given by a few jurists. According to Mu'jam al-Asasi, bribery is a form of giving without the right to fulfill the wrong or wrongful needs. While according to Fatimah Mahbub in Al-Mawsu'ah al-Dahabiyah, she defines bribery as a gift to fulfill an interest. For example, a person may pay a bribe to a judge or other authority to follow their desires and interests. According to Ibn Taymiyyah, when a leader transfers his talia in a matter from a person who is deserved and better to another person who is entitled on the grounds of family relations, liberation, friendship, or because corruption acknowledged either in the form of services or property, then the act is a betrayal to Allah. Therefore, from the definition, it can be concluded that corruption has a broad scope of meaning. In the meantime, corruption can also be described as an act of taking, obtaining any property, power, authority in a way that is void, in the interest of an entity or a party to whom the absolute rights of the thing or property belonging to another person, or may also belong to another person. I will pass to the next presenter. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is SYARIAH binti Ibrahim. With my seat number 057329. And today I want to present about the factor in the symptom of corruption. Firstly, the impulse of lust. The impulse of lust is one of the causes of corruption. It is because when a person who is too sentimental or too greedy for wealth, they will commit any crimes like corruption regardless of sin or reward. Secondly, ignorance. Ignorance is the main causes in the outbreak of corruption. So we can look here that the education of knowledge is very important. Moreover, an education in religious matter. With the knowledge of religion in our life, it will make us a pious person and also will increase our faith in God. So the corrupt politicians can be curbed. After that, feelings of great weaknesses of leaders and organizations, the abuse of harsh law, and the practice to give the gift. Next slide. Now move to punishment of ta'zir. In the Sharia criminal code, ta'zir is an offense where the punishment is abuse, which is the offenders are not sentenced to qisas or hudud. The punishment of ta'zir is submitted the discretion of the judge balanced with the guilt of the offence committed by the criminal without interference from other parties. Meanwhile, in Sharia terms, ta'zir is the basic punishment of a sin for which there is no limit or expression. So, in choosing the appropriate punishment of ta'zir, the judge must look at the background of the offender and also look at the type of the offence that they committed as well as the impact on society. That's all from me, and I will pass to the next presenter.
Okay, my name is Wanafata binti Azhari. My matrix number is 057342. The next point is the form of ta'zir punishment. As we know, the determination of the ta'zir punishment is left to the discretion of the judge or the ruler of the state to choose the suitable punishment to be inflicted on the offender. Among the part of the ta'zir punishment, they are beating, detention, and reproach, and the other punishments. The aim of the punishment is to give repentance to the offender to purpose. The the punishment is based on ijtihad of a judge or his representative to is in accordance with the offender, and the circumstances. That's why the punishment will be different based on the judge discretion on how they look for the condition of the offense and the offender. Then we have some constraints of the punishment. Firstly, the prescribed punishment is not prohibited acts, meaning that the punishment is not against the Islamic rule. So the judge must conduct the punishment according to the Islamic rule. Secondly, the punishment must be adapted to the circumstances as prescribed in the case of the person defending himself. Regarding the way of punishing the ta'zir crimes, the Sharia has laid down a list of types of punishment which vary between a lightest punishment and the severest one. This pose a light if a light punishment, then the Prophet said, whoever punish a limited offense with a limited punishment, then it belongs to the group of those who over the limit. Next slide. Then we have condition of ta'zir. For the condition, we only have one, which is sensible. So the punishment should impose to a man or woman, to Muslim or non-Muslim, to puberty or a child, as they are eligible to receive the punishment unless they are a child who not reach the puberty yet. That's all from me.
Okay, Assalamualaikum. My name is Samira binti Masaid. My matrix number is 057352. So today, I would like to talk about application of ta'zir punishment in corruption criminal offences in Malaysia. Okay, when it comes to the issue of corruption crimes in Malaysia, if the offence of ta'zir is discussed, the penalty is also dependent on ta'zir, which is required applied to punish offenders of corruption. Since hudud and qisas sentences do not apply to corruption offences, so these two laws cannot be used to prosecute corruption. As a result, the penalty is sufficient in terms of the type of offence, the type of punishment, the manner of punishment, the condition of conviction, and also the manner in which the sentence was carried out. The fact that there are no takzir limits on age or religious is intriguing, which takzir grants judges broad discretion and applies to both children and adults, Muslims and also non-Muslims. Therefore, if we look at the current situation in our country, Malaysia, we can see that corruption crimes are committed by variety of people. Usually, when we considering about their religious background, the suspect's religious background, who are usually a mix of Muslims and also non-Muslims, then it is preferable if the takzir penalty is enforced for non-Muslims. The rule of takzir punishment, as we know it, it is to protect society's well-being from harmful things that, through their acts, the crime of corruption is capable of leading to society's social harm and bringing a nation to ruin. Also, as a result, it is better to use these takzir sentences as effectively as possible in order to deter the crime of corruption. Okay, next is the effectiveness of takzir punishment in the context of corruption. Okay, in the penalty of for the crime is based on the punishment of takzir as described in Islamic law. It is likely to be effectively because the takzir gives judges more space and more power to enforce heavier sentence through Sharia courts. This is important as takzir penalty is more to educate the offender and also society, as well as training them not to commit the crime in the future. To ensure that this is possible, they must allow Sharia courts to enforce the law based on takzir. The Islamic criminal crimes enactment also needs to be amended so that it can provide wider jurisdiction and also provisions that criminal punishment is based on takzir can be performed. So that's all from me.
My name is Nabiha Anisa binti Ahmad. My matric number is 057331. I will talk about proposals toward the implementation of takzir punishment for corruption crimes. First, amend the criminal offence of corruption enactment in every state. We've introduced new provision with respect to the criminal offence of corruption. However, there will be an issue related to jurisdiction, whether involving the states, the jurisdiction of Sharia courts and civil courts, or involving federal constitution. Second, judges should be given incentive courses and training with respect to takzir punishment, with regard to the punishment for takzir, so that they are better prepared to face any challenges in the future. Thirdly, punishment based on takzir need to be examined for its effectiveness. If appropriate, it can be widely practiced and applied in matters that relating to corruption. So not only the civil court can give punishment of corruption offences, but Sharia court is also given power, even if it is only applied to Muslims. It can help facilitate all parties, especially the courts where corruption cases in the civil courts can be reduced with the assistance of the Sharia court. Lastly, conduct various awareness campaigns through various aspects, whether mass media, electronics, public talks, briefing, and others need to be expanded and their effectiveness evaluated. So, in the conclusion, an act of corruption is an act that turns out to be wrong and void. From the point of view of its own meaning, it is enough to describe it as a wrong act. So that's all from us. Thank you.
Thank you.
Thank you.